Good afternoon, ladies and gentlemen. Once again, welcome to another series of webinars by CIO East Africa. Today, our focus is on data protection laws and governance, and I think this ties very closely to some of the things we've been talking about in the past couple of weeks around cloud, around digital transformation, around working from home, around security, and with the current pandemic, of course, there's a lot of data that's being collected left, right, center by organizations. In fact, the other day I was watching CNN where this organization had come up with a solution, or this company had come up with a tech solution that could track anybody who had interacted with somebody who tests positive for COVID-19. And the big debate on CNN was, is this invasion of privacy or is it okay to do this? You know, so there's obviously a lot of discussion around data privacy and data protection laws. What are governments doing about it? What is especially happening in Africa? Because this is where we are. We know that in the European Union, they already do have their GDPR law, which they've put in effect. But what is happening from a local African perspective? So without much ado, I'd just like to quickly introduce our two speakers for the day. We have Mr. John Omo, who's the Secretary General of African Telecommunications Union, who is going to be our first speaker, and we look forward to hearing from him. And then after that, we have Irene Omeri. Irene is a security consultant. She's been doing this for very many years, and she's the founder of ISFA, and she will let us know a little bit more about it. As usual, the house rules. Please, let's post our questions in the Q&A window. Irene has posted her presentation in the handout section, so you can download it from there. Let's engage in the public chat window if you have anything you want to share with the presenters, or you want to let us know if you can't hear something, if you can't see something, let us know through the public window. And we do look forward to an engaging session. I'm actually very excited about this session today. It looks like these webinars have become a real learning series. And when we have experts on board, like the two speakers we have today, I'm sure our notebooks will be full of information and knowledge that will help us as we continue to work from home. The floor is yours, Mr. John Omo, and thank you so much for agreeing to do this in the CIO webinar series. You can now take it over.
Thank you very much indeed, Laura, for that wonderful introduction. Again, it's good to collaborate with CIO for such a topical issue that is the trendy thing that everyone talks about. I've been introduced as, and so I won't go so much in terms of my background. Essentially, I work for the African Telecommunications Union, which is an African Union Commission organ that coordinates the development of ICTs in Africa. And so the organization is at the core of issues of data protection and privacy. As I introduced the topic, increasingly we are seeing a modus of operation in ICTs where the motto is to go faster and further, to be more efficient, to be more effective in terms of integrating each and everything that involves human beings. Interaction between ourselves and interaction between ourselves and other what I would call things. And that generates, gives us more time, gives us, as I say, more effectiveness, brings in more income and power of control. That essentially is the paradigm of the digital society and the economy. And so without a system of governance, we then grapple with the problem of a wild west, if I can use the terminology that is always used in America to describe a system where there are no rules. And so we would have, fundamental human rights, for example, being abused. We'll have issues of security. You'll have issues of morality. You have issues of whether what we expose, for example, now that our children are mostly learning from home, they have access to virtually anything that goes on everywhere in the world unless there are systems of control. And so you have those issues to grapple with. the African Union Commission last year at the ministerial level adopted a digital transformation initiative for Africa, and at the core of that initiative is the issue of data governance, data management in Africa, and privacy. And so we have that as the context of our discussion. Now, this slide is impressive to me for one reason. I got it from GSMA, published in July last year. And the reason it's impressive to me is it basically gives the context of where we are. We have Europe at the top with GDPR, quite an elaborate system of data management. We have, what we would perceive as economic benefits, societal benefits of effective, efficient data management. You have issues of cross-border data laws to deal with, or data systems to deal with. How is it that because data is the new oil, in fact, it surpassed the new oil, it's surpassed oil. And so if my data is being used across the borders in a manner that I've not authorized, what would be the system of rules that govern such use? We have seen a system in Africa. I'll talk about this a little later. The Malabo Convention. We have seen a number of regional initiatives within Africa, for example, in the SADC region. So a couple of initiatives within Africa in terms of dealing with the subject. Now, the reason I say this slide impresses me is that probably for the first time, Africa is presented in white. Africa is always presented in black. And when you're black, it is blacklisted, it's a black horse, black associated with things that are not right. But Africa is presented in white, probably as a sign that good things are happening, good things are on the way. Now, I did talk I did mention the issue of the Malabo Convention on cybersecurity and personal data protection. This was adopted by the African Union heads of state and government in June 2014, virtually 5-6 years ago in Malabo, and hence the name Malabo Convention. Essentially, it tries to harmonize the laws of African states on electronic commerce, data protection, cybersecurity and promotion of cybersecurity promotion and cyber crime. Looking at the convention, it adopts quite a holistic approach to cybersecurity, cyber governance, personal data protection, and imposes certain obligations on member states to establish national legal, policy, and institutional arrangements for management of data. And so it requires, for example, issues of notice, choice, and consent. These are the key issues that are in the convention: notice, choice, and consent in terms of personal data when used, data security, data access and correction, data equality and integrity, data retention and destruction, registration with the National Data Protection Agency, and cross-border data transfers. What regime would govern such transfers? What regime would govern breaches of systems that have been agreed on in terms of data management and the appointment of data protection officers in our countries? Unfortunately, which is the key issue that we have to grapple with in Africa, is that a minimum of 15 countries would ratify or ratify the convention for it to enter into force. As yet, unfortunately, I think there are now 6: Ghana, Guinea, Mauritius, Namibia, Senegal have since ratified it. And so, in as much as the convention has very lofty ideals, has systems that would govern transboundary data transfer, it is, as of to date, not in force. Now, this picture I got from D.L. Piper. They published it last year. And so it's good to compare or look at Africa and the world. Now, unfortunately, some portions of it may not be so clear, but the shades in red present jurisdictions with what is considered as effective, adequate, efficient data protection rules. You'll see that largely extends to Western countries, Europe and the North America essentially. And then we have the second tier. I'm a bit of colorblind, but where you see China, for example, you'll see a bit of Singapore, Malaysia, and then you'll see Morocco, Tunisia, the only two countries in Africa that would be considered to be nearly there in terms of their data laws. And then you have the third tier, which comprises largely of the BRICS. You have the Brazil, you have South Africa, a couple of other African countries, and the former, or rather the Russian Federation. And then of course you have large swaths of Africa, all that, that by the time the publication was made last year are considered to not have so much of effective data legislation. So the red presents heavy, where data is controlled heavily in terms of systems that manage how it is generated, how it is applied, how it is transferred, how the breaches of systems that are put in place would be met. Then you have countries that are considered robust. That's where you have China, you have a number of Southern European countries. And then you have what I would consider yellow, modest, and then green, limited. And then you have large swaths of Africa, as I've said, in white, representing systems that would not be said to be effective at all. Again, this is another presentation that raises the situation as was. This I got from UNCTAD. UNCTAD conducted a study worldwide. 106 countries were involved. In Africa, the study involved 54 countries. So essentially, just one country in Africa was not involved in the study. Of the 106 countries that were studied worldwide, 70 of them were found to have legislation that could be considered effective, in place. Worldwide, 11 of them had draft legislation. 20 of them had no legislation. And the unfortunate thing is that 5 of the countries that were studied, no data could be found. Essentially, that is, you send a questionnaire, you seek to speak to someone responsible in a particular country, and everybody goes mute because they are not willing to discuss the issue. Now, fortunately for Africa, 27 of our countries out of the 55 countries that were studied, which is essentially 50%, had some form of legislation. It may not be encapsulated in what is called a data legislation, but some form of legislation that mentions data issues. 9 of them, which is 17%, had a draft legislation. 13 had no legislation at all. And 5 of those countries were unresponsive, essentially what I've said. So it's most likely the case that out of the data that UNCTAD was collecting, the 5 that did not respond worldwide, of those 5, all of them were in Africa. The figure presents, African countries that have some, personal data protection and a regulatory landscape for data. And in terms of, again, the countries that would be considered robust, I'm sorry, parts of the slide are running off the screen. but you'll see that quite a large number in green are in the western belt of Africa, those that have some data protection and privacy policies. So you have Senegal, Mali, Burkina Faso, Cote d'Ivoire, Ghana, and Benin. Of course, joining Morocco, because as we saw it, Morocco and Tunisia, as you saw in the earlier slide, those two countries have some quite almost near what one would call robust data protection legislation. And so you have countries in blue. Of course, Kenya was, by the time of the study, in blue. Now the legislation is in place, albeit there are portions of it that have not been brought into force, and the appointment of the administrator of that legislation is still in process. You have countries in yellow, where there's what we would call some hope, and then what you see as white. What you see as white is there's still not very much happening, or there's just no information. So you would say that almost more than half of Africa still has quite some work to do. Now, of the countries that had some form of data protection that we have seen earlier, you saw Madagascar, South Africa, a couple of countries in the West. These countries, and of course now Kenya will be included, these countries have prescriptions in their data legislation that provide for how cross-border data transfer is to be dealt with, the sort of restrictions, the sort of conditions under which that can happen. And also the ones, they also do have, rules of breach in their countries, and also require some form of a reciprocal arrangement with countries where their data is transferred across the borders. So that represents a picture. Much of this, as you see, is in the West, of course, with South Africa taking the lead, and in the North, again, Morocco and Tunisia leading the pack. Now, just some, I got this from Deloitte, a study that was done by Deloitte. Again, the two slides that are presented about Africa is out of this study by Deloitte that was conducted about data legislation in Africa. And so there's some existing, there are trends in terms of that report. The African Data Protection Authorities in enforcing that personal data protection legislation. And where we have seen a lot of movement or a lot of activity by data protection agencies is in Ghana and Mauritius, where there's robust action being taken against breaches of data protection legislation, with huge fines sometimes, meted against those who do not comply. So Morocco has had also a trend of investigating data protection practices of several websites within Morocco. Of course, for sites that are outside of Morocco, they would have to have reciprocal arrangements. But the key issue that Morocco has had to grapple with is how agencies collect and process personal data in the context of providing online services. We have Angola, Cape Verde, Madagascar, Mali, and South Africa, where there's some activity, but not as effective as Morocco, Ghana, and Mauritius. And so those are some of the trends that we will need to keep watching in terms of how countries that have passed data legislation, go ahead to enforce those data laws. Again, we are dealing in a context where there's a lot of transboundary nature of data, and there are a lot of interest from huge data users and processors for personal gain. And the interest of African countries is not so much, or the interest of individuals. It's not so much the interest of those organizations. And so we need to watch out in terms of how we deal with multinationals, big organizations that are interested in our data. As I head towards my summary, we need to ensure again that even for countries that have passed data legislation, that there's adequate and effective protection of personal data, because it's personal to the individual. When it's personal to the individual, it reveals information that the individuals should be, the consent of that individual should be sought in order to deal with that data in the form in which it is proposed to deal with. We also need to encourage investments in data management in Africa. And so, organizations that seek to use data in ways that are productive to our societies, but also make money in the use of that data. Organizations that seek to innovate. For example, we think that there's a lot of data sitting in our governments, and that data is not being used to put into productive use. And so there's merit in encouraging organizations to access that data for commercial use, as long as the data protection laws are complied with. I think there's also merit, and we don't see so much of this in legislations in Africa. Incentivize good data governance through the concept of accountability, merits, giving awards to organizations that manage data in an appropriate way. And that would have to be a scheme that probably would be worldwide. Flexible technology and sector neutrality is a concept that is quite dear to this industry, that in as much as we manage our data, we need to ensure that that is technology neutral, so that it doesn't discriminate between one technology and the other. And then the last essential element is to allow data, especially for commercial reasons, as long as personal protection data laws are complied with, that data is able to move across borders easily without undue hitches. There's more to data management that is now in vogue, and this has to do with the processes of collection and data processing. And as we move into the more intelligent technologies such as artificial intelligence, we need we'll see a lot more of data collection depending on the field of application, particularly in the case of artificial intelligence. And so data will be collected, not so much in the form in which we know it, you get into a library and look for data. But artificial intelligence equipment will be gathering this data from ourselves, and we'll see a lot more of that. Storage and data management by operators and service providers, including OTTs, of large volumes of sensitive data. Private and critical information is increasingly becoming the norm. OTTs move huge amounts of data, largely for commercial reasons, and we're likely to see more of that. I don't want to go into how COVID-19 came, but some unfounded rumors that it was in a lab for us to be immunized with some chip that will not, you'll not get to know of it, but collecting information about one. Lastly, under this, identification and geolocation and tracking of connected individuals and objects in the case of Internet of Things will increasingly become the vogue. Let me conclude by just saying that as we move forward, again, I've mentioned this, but developing innovative investment models, benchmarking with jurisdictions that are more effective, or what would be deemed as more effective data protection legislations, but to contextualize it to our circumstance, simplifying and relaxing, the mode of legislative development in our country. It takes, say, 5 to 6 years for an African government to develop a policy framework and get legislation effective. 6 years. That cannot work in the world of modern data management. So we just need to have a framework law that would facilitate effective management of data and leave the nitty-gritty of it for regulators, for policymakers, so that there's more flexibility. Skilling periodically is something that needs to be with us throughout. We need to ensure that our decision makers, our legal, technical staff are always, all the time, skilled in data governance and best practices, because that is the only way we can be ahead of the game. Again, I dare say that there's merit in Africa speaking together, and so there's every good in one or our countries, ratifying instruments or conforming to policy guidelines that have been agreed upon at the African level. So allow me to stop there, and I will be able to take questions as they come in. Laura, thank you very much for the opportunity to give this presentation. I will be posting this slide in a short while in the handouts for those who want to have it. Thank you very much once again.
Thank you very much.
I hope I got to my time, Laura.
Well, you are slightly over time, but very good content. That's what matters.
Thank you, Laura.
Yeah. So I will just request you to mute your mic and put up your camera until we come back for Q&A. Now, just some interesting things to recap John's presentation. It's actually very comforting to know that the African Union is looking into this whole data protection and governance situation. And just to hear about the Malabo Convention is very encouraging, and good to know that at least a step has been made in the right direction. We just need to come together as Africa and just keep pushing this agenda for ourselves, because there is that thing of dealing with multinationals, and when you look at the GDPR, it completely exposes us. So we can't continue moving at the slow pace that we are moving at. And as the invitation from CIO East Africa said, and John has re-emphasized and said it, data has surpassed oil. And as someone said in the last Africa Tech Summit that was had in Rwanda at the beginning of this year, there was a discussion around data being the new blood. So this is it's not even a joke anymore. It's something that we seriously need to look into and fix as soon as possible, especially if we intend to trade globally. So it has become a matter of urgency. So up next, I want to call Irene Omeri, who I had introduced earlier, to deliver her presentation. As mentioned, please post your questions in the Q&A window. We would really like to finish by 3 o'clock today. As you noticed, we moved the webinar by an hour earlier because John has another webinar he needs to get into by 3:30. So we're going to try and respect time and finish on time. Irene, the floor is yours. Please take over. Irene may be having a few challenges here and there that are beyond her control. So if she drops off, please do bear with us. We may just jump into the Q&A in case of anything, and then take her back in when she's back. Thank you. Irene, the floor is yours.
All right, thank you, Laura. Good afternoon, everybody. My name is Irene Omeri, and this is about me and my experience. Primarily, I've been focusing on data protection and privacy for the last 3 years, although my interest extends further than that. I've got 20 years of information security experience. I've worked at the UN Secretariat on their ISO 27001 certification program. And I've also developed an ICT security strategy for the Ethiopian government. I've got a strong background in IT, but primarily I think that the emphasis should be on people. Technology doesn't solve anything. Solutions have to be people-centric. So my interest in data protection and privacy, it came from a personal standpoint, because 5 years ago, I discovered that a fake LinkedIn page had been set up in my mother's name. And I contacted LinkedIn about it, and once they did their investigation, they took down the page. But what was interesting was that on that page, apart from her name, under the contact info, her email address was listed. So that made me think maybe the people who set up the page had access to her email. So I tried to contact the service provider, not directly, but because I know people in the industry, I got them to ask on my behalf. So an approach was made to the chief security officer of the email service provider at the time. And the recommendation was that her account be frozen. However, their legal department jumped in and said they would not do that unless my mother was on the phone to answer the security questions. Now, that day in question, my mother had dementia and she'd gotten lost that day. So we were trying to look for her. So at that particular point, when the message came back, I didn't actually know whether my mother would be found alive. So you can imagine how infuriated I was with their response. So for me, I see data protection legislation as bringing some kind of accountability at a personal level, but also, and this leads on to my next slide, what does accountability for political misinformation look like when a British company uses an American platform to influence political discourse in a Kenyan election? Now, this is taken from an article that was written by Nanjala Nyabola. The link is below. And it goes back to what I'm saying, because, you know, who do we turn to as Kenyans? Who do we turn to when things like this are going on? And just for some more context, the British company was Cambridge Analytica. The American platform was Facebook. And I think maybe John touched on it in his presentation. In the global South, we are at a disadvantage when it comes to trying to get information out of American platforms, for example. Because when I contacted the email service provider, I was then told that I would then have to go I would have to seek a court order from the US in order to access to be given information about my mother's personal account. Now, unfortunately, my mother passed away a few months ago. So, this just goes to show you how these platforms think, not just at a personal level, but just harking back to what Nanjala writes in her question, there is no accountability. And it's only, I've spent a lot of time in the UK and I can see that parliamentarians there can ask questions that push some of these big companies to act. But here in the global South at the moment, we're at a disadvantage, and that needs to change. So I think, John, I saw some of his slides. He touched on this, and at the moment, 29 African countries out of 55 have passed data protection legislation. So let's get into Kenya's Data Protection Act. Okay, this is some statistics about some numbers for Kenya, the population, mobile phone, internet usage, and social media. So the Data Protection Act of 2019, okay, so the date of assent was 8th of November and date of commencement 25th of November last year. Now, if you contrast that with the GDPR became applicable on the 25th of May 2016. It became enforceable on the 25th of May 2018. So there were 2 years for it to be implemented. This Kenya Data Protection Act, it's taken effect, but there are glaring holes, one of them being that the Office of the Data Commissioner is yet to be established. So at the moment, contraventions against the law are proceeding, but we as data subjects don't have any recourse because the data commissioner hasn't been appointed. Now, under Section 8 of the Act, the data commissioner shall keep a register of data controllers and data processors. So just to define what a data controller is, they determine the means of processing of the personal data, and a data processor only processes personal data on behalf of the controller. So what do I mean by processing? It means any set of operations performed on personal data, such as collection, recording, organization, structuring, storage, adaptation, alteration, or retrieval. Now, currently, to go into most office buildings in Kenya, you're required to sign in. Normally, it would be your name, your telephone number, your national ID card. So whether those security people like it or not, under the Data Protection Act, they are acting as data processors because they are processing, so collecting that information on behalf of the data controller, who is the company for whom the security company is providing security, as it were. Now, they have responsibilities, but at the moment, I'm not sure that they know what they are. Specifically, there is a limit to how long you're supposed to retain personal information. When those books that you sign in on get filled up, what happens to them? How long are they kept? Where are they stored? You know, all these kinds of things. And I'm hoping as time goes on and data subjects become more aware of their rights under this act, there'll be maybe some pushback and say, okay, so when I sign, where is this information going? Okay, so I wanted to just highlight some of the areas where contravention of the act takes place. So I signed up for a functionality of M-Pesa earlier in the year, and I'm not sure whether you can see this clearly, but these are messages that I received saying, okay, presumably because I had that functionality added. Now, this contravenes Section 8, Section 28, subsection 1, paragraph C. The data subject has consented to the collection from another source. I didn't consent to my number being passed on to these other loan service providers. And more importantly, I think what is a real issue here is that there is no header on these numbers. So it could be anybody. I don't know whether or not they're genuine. Okay, then the next slide. Yes, I have bought things from Boopass, Food Plus, Pizza Inn, but they need consent to market to me, but they just send me messages. Now, on the Pizza Inn one, it says that I can stop this message if I dial that number. I have tried it twice. It has failed. So if anybody on the call has been successful in stopping messages like this from being sent to their phone, please let me know. Now, the only acceptable message from here is the Ministry of Health, because, you know, due to the ongoing COVID-19, they are sending messages to all mobile phone subscribers just to keep them alerted as to what is going on. So under the Data Protection Act of 2019, the ability to opt out must be provided in every communication that somebody has with you. Now, one of the things that is required is under Section 41 of the Act, every data controller or data processor shall implement appropriate technical and organizational measures. Now, okay, I took this photo last year in October. This was the landing page of Huduma Number. Huduma Number is Kenya's flagship biometric identity verification project. those who enrolled in it had to submit their biometrics. So you can imagine my surprise when I went to this website, and the first thing my browser flags is that it's not secure. So, I mean, that kind of made my head spin, because I'm thinking, okay, this is a flagship government project, and you're saying that, well, not you're saying, you are collecting the most sensitive information from your citizens, i.e. their biometric information, and yet your landing page isn't secure. So I subsequently contacted the communication authority, and it was rectified. But this is a major omission on the part of whoever is running the website of the Huduma number, because it doesn't instill confidence in me as a citizen if the website doesn't have HTTPS. That nowadays is standard, so that should be implemented across the board. And I can tell you now that there are other star.go.ke websites that do not have HTTPS. So it does make you wonder why best practices about website development have not been communicated to those responsible for developing .go.ke websites. Okay, so moving on to data breaches and fines. The ICO referenced here, that is the UK's Data Protection Authority. Under Section 4 of Kenya's Data Protection Act, it references a data controller or a data processor not established or ordinarily present in Kenya, but processing personal data of data subjects located in Kenya. Now, what I wanted to do here is to highlight how the ICO goes after organizations that have experienced data breaches that have exposed the personal data of UK citizens. Under Kenya's Data Protection Act, the Office of the Data Commissioner will also have that capability. However, what I did want to highlight in the next section is the Facebook Island. That was in relation to the Cambridge Analytica scandal, and the fine was implemented in October of 2018. However, I think they were investigated under the previous data protection legislation. So under that piece of legislation, £500,000 was the maximum that the ICO could have fined Facebook Island. Under the new Data Protection Act of 2018 in the UK, the ICO has the opportunity to fine Facebook up to 4% of their global turnover, which would be hugely significant. So the DPA 2018 that was established to take into account the General Data Protection Regulation gives data protection authorities a lot more leverage to fine organizations that flout the GDPR a lot more money. And at the moment, there are cases that are going through. There was an enforcement, I think, an enforcement notice for British Airways that they were going to be fined £283 million. And so you see that actually concentrates the board if you know that you can be fined up to that amount of money. Now, the Yahoo one at the bottom is interesting because I don't know whether you remember, Yahoo's data breach actually occurred in 2014. However, you can see that the fine was issued in May 2018, and that's because Yahoo took a really long time to make that data breach public. So, and the ICO, which is one of the more resource data protection authorities in the world, it took them a number of years to actually investigate and to issue these fines. So I suppose that's something that once this Office of the Data Commissioner is established, yeah, we'll have to see how, you know, the resources can be applied so that, you know, external companies don't get away with it. Okay, so moving on. So COVID-19, this was an article from The Standard about how the state will be tracking those in isolation to ensure that they do not breach, you know, don't say that they're in one place when they're somewhere else. And around the world, you have apps that are being used to test, trace, and track. Now, under Kenya's Data Protection Act, Section 31 would require a data protection impact assessment because of the high risk to the rights and freedoms of data subjects. Okay, now looking ahead, one of the organizations that are available to the data protection and privacy authorities of Commonwealth countries is the Common Thread Network. And African member countries are Ghana, Mauritius, and South Africa. So that is an organization that whoever is appointed Kenya's data commissioner should be seeking to join, purely in terms of capacity building and, you know, just maybe seeking to establish knowledge exchange and, you know, just acting as a sounding board because, you know, one thing we've learned, we're all connected, and it's good to share knowledge in these membership communities so that those who have more experience, like Mauritius, Ghana, and South Africa, and you know, more widely Canada and various other places, the Office of the Data Commissioner, Kenya's Data Commissioner, can learn from them and maybe implement best practices as they see fit. Also, with regards to their the Data Commissioner's in-tray, one of the things that they should be seeking to do is to educate data subjects in Kenya about their rights under the Data Protection Act, and most importantly, to raise awareness of the responsibilities of data controllers and data processors among relevant organizations. So that's me done, and I look forward to answering any questions you might have. Thanks, Laura.
Thanks, Irene. So now we're going to move into the Q&A. But just to recap some of the exciting things you've talked about today, you know, sometimes some of the things that happen in our personal lives are the ones that make us make certain decisions and become very passionate about them. So the story of your mom and the LinkedIn is, you know, it actually brings the story home, and we can stop looking at these data protection laws and governance from a distance and do realize that it can actually happen to us in our homes, considering right now with the new working from home. And even the opting out, it's very sad to know that, or rather to note that even if you try to opt out of some of these marketing messages, it doesn't happen. You know, so what is the next step after that and what can be done? So because we are running out of time, we have about 10 minutes to 3 o'clock. We will try and do the Q&A between now and 5 after 3 and then close off.